So for everybody who's joined in, today Mr. Amir from Dhir Associates, he's a principal associate with the law firm, will be giving us a brief about all the latest highlights of Insolvency and Bankruptcy Code, which is a very recent code and has come in 2016. He'll run through it through an amazing PPT. And everybody who's joined in can ask their questions towards the end of session. We'll keep specifically 15 minutes for question and answer. And I hope everybody has some takeaways from today's session. Over to you, sir. Probably you can start with the brief.
Yeah. Good evening, everyone. I know it's a weekend, but it's just going to be a 1-hour session, and I'll only take your time for 45 minutes, and then we can have 15 minutes of Q&A session. Here's my brief profile. I am a LLB LLM grad from Osmania. I've also an MBA from ICFA University. I work with Dhir Dhir Associates, a full-fledged law firm, and I take care of their Hyderabad office. We have offices in New Delhi, Bombay, Hyderabad, and Japan. And we also have a couple of my colleagues today with us who have helped me in this wonderful PPT, Ria as well as Rishika. They'll also be assisting me. Next, please. So let's dive into the subject quickly. So I'm sure that the most of the crowd on the Zoom as well as on YouTube must be aware of the IBC, the code as itself. So I'll keep it concise and won't go deeper into the sections which we all already know. I'll just dwell into the recent changes which has happened. So let's just go a bit back. So what are the objectives, or what are still the objectives of Insolvency and Bankruptcy Code? The first one is the resolution of the corporate debtor. The second is the maximization of value of the assets. And third is balancing the interest of all the stakeholders. Because of the COVID-19, various disruptions have happened, and because of which the creditors as well as the debtors have been affected. In fact, debtors have affected more the creditors, because the entities are now struggling to run their business as a going concern. There's a liquidity crunch at the financial institutions. Massive financial disruptions have happened, and limited revival plans for the corporate entities are coming in. This is so because the people are not at this moment in this COVID juncture not willing to go ahead with filing a resolution plan. And there's a value erosion due to the time overrun of the resolution process, because as we all know, in the lockdown, no financial activity could take place, and hence it has been more like a deadlock. Next, please. So these are the changes which has happened in the last year, the COVID year, as we say. So through a gazette, section 10A was inserted into IBC, and which calls for suspension of the initiation of CIRP for a period of 6 months, expandable up to or extendable up to 1 year. It was extendable. It was actually extended twice by 2 MCA notifications, 24/9 and 22nd of December. So right now it stands that no new application can be filed for the default after 25th of March. And NCLT has decided this case that though this came into picture in the month of June, this notification is retrospective, and that the case was Ramesh Kemal. You may just note it down and you may just go through it at a later point. Next, please. Also, the threshold has been increased from 1 lakh rupees earlier to 1 crore rupees now, because that this was done by our Honorable FM, Mrs. Nirmala Sitharaman, that because of the COVID and all the disruption of the activities and the financial constraints, the threshold has been increased. So if you want to file section 7 on behalf of a financial creditor, section 8 notice, and section 9 on behalf of operational creditor, or section 10 suo moto by the corporate debtor, it has to be prior to 25th of March. After 25th of March, they are considering as a default as a COVID default, and no new application can be filed. The threshold limit for the filing, even prior ones, that's before ones, have been increased to 1 crore rupees. And these are the two judgments. One is of NCLT Kolkata and one is of NCLT Chennai. They both discuss that the threshold limit of 1 crore rupees, it is also applicable to the fresh filings which are happening post 25th of March, but considering the default prior to the 24th of March. This case in Tarkan Web Innovations Private Limited NCLT Kerala case, what has happened was Section 8 notice was issued prior to the lockdown. That is prior to the notification. Section 9 application came to be filed after this notification. What NCLT Kerala hold was that because the debt due and payable, the date of that default was prior to this notification, hence this section 4 threshold limit would not be applicable. But it has been stayed by Kerala High Court. Now the case is still pending, as far as I know, that it's still pending adjudication, because there has to be some kind of a balance which is to be drawn down by the High Court or by NCLT or by the Supreme Court at some time, that what if the default is prior, but the section 9 could not be filed at the time. Like for an example, just say on 20th of March, I have given a section 8 notice seeking an initiation for CIRP for the corporate debtor on behalf of an operational creditor. So to go to section 9, prior to that, I'll have to issue section 8 notice, right? So if I have done that just a couple of days prior to the notification, then can I file? Yes, you can file it if it's more than 1 crore rupees. But can I file even if it's less than 1 crore rupees? So this thing has to be decided, and this is still sub judice. Next, please. This was actually the need of the hour because everything was closed. None of the IRPs, RPs or liquidator could work. People were not willing to step out. There was even after the lockdown was lifted, people were not willing to step out because of various guidelines of the government. And during the lockdown phase, it was all on standstill. So the lockdown period was excluded from the corporate insolvency resolution process time period. And it was actually to be, the time limit for that was from the lockdown date till unlock 1. But then it so happened that it was extended till 31st of August. And then in the case of Global Softtech, that was a case of wherein the resolution professional was Mr. Hemant Sharma. And this was extended till 15/9, considering the various facts of the case. Then because of the various disruptions which happened in this particular case, it was, I guess, the union territory which was also concerned with the state of Maharashtra. And because Maharashtra was extending lockdown, the state was extending lockdown, the whole period was excluded. Next, please. Yeah. So what has happened is the role of the insolvency professional entities also has been expanded last year. So Regulation 12 of the Insolvency and Bankruptcy Board of India, Insolvency Professional Regulations 2016, was amended with effect 1/7/2020, which has now expanded the role of IPEs, Insolvency Professional Entities. So I'll just give you the brief background of the whole thing. So there was one disciplinary committee formed for one insolvency professional. In that, one of the thing which was discussed was that the insolvency professional was not part of an IPE, that is insolvency professional entity. So the services which he could have availed for say, like, 1.5 lakhs or 2 lakhs, he had to pay a huge amount, because earlier it read as all the insolvency professional entities would provide services to its own partners or the directors. Right now, what this has done is, after this amendment, they can provide services to any insolvency professional. And I can also remember one article, I think it was in Financial Express, where Mr. MS Sahu was addressing this topic. So he categorically stated, now how we have law firms or the different entities or big fours, That is how they are planning to have this insolvency professional entities, so that in one entity you can have lawyers, chartered accountants, company secretaries, all at one place, and they can help the whole CIRP process for the insolvency professionals. With this amendment, they can do so for any insolvency professional. It need not be from their own LLP or from their own company. Next, please. Yeah, this has actually brought a very nice change in the whole liquidation process. See, there are a lot of not readily realizable assets which are associated with indefinite waiting time frame, and I've also given few examples. Sundry debts are there, or there are some refunds from the government and its agencies. There are contingent receivables, disputed receivables, sub judice receivables, and then you have the whole tranche of PUFE, preferential, undervalued, extortionate, and fraudulent transactions. So I'll also give you a brief background of this. What used to happen earlier was, like, the CIRP process is ongoing. RP would, or the resolution professional would file an application for PUFE. That will still be ongoing, and the resolution plan must have been approved by the honorable adjudicating authority. Now, what happens is, this whole thing actually disrupts the liquidation process as well. Like, for an example, now you think from two perspectives, because in both my slides which are coming forth, I've explained both the scenarios. The first scenario is an example of a entity whose resolution plan has been approved. Are you trying to say that this is what the jurisprudence is evolving? That are you trying to say that the company who has bought in, or who has been a successful resolution applicant, would he get the amount, or would the financial creditors who have invested would get the amount? What amount we are talking about? The amount of PUFE, the application which has been filed by the RP to get back the amount, which is still yet to be decided by the NCLT. So who would get back this amount? So this is one question. Second point is, under liquidation process, if the RP is, or the liquidator at this juncture, is selling all the assets, and he is unable to sell, just say a small amount of assets which are involved in this, in this blue box which you see, which are part of all this. What will happen? Will that create a deadlock for the company to be wound up totally? He cannot file the final application for closing down the company. Liquidation process would be at a standstill till this application is decided. Now let's coming back to this. Previous one only. Regulation 37A. What this is deciding is that if the liquidator feels that of the assets of the stressed firm which are involved in all these activities, he can transfer this, because these assets are not readily realizable assets. So he can transfer these assets to any person considering section 29A, that it has to be on arm's length basis. For this, he would have to take into confidence all the stakeholders. So the stakeholders consultation committee is formed. It is not necessary for him to go ahead with their decision, but he has to consult them. Then he can use his own acumen and can decide on this. So this would actually help the liquidation process conclude permanently, easily. Now, yeah. So liquidation process regulation 38, transfer of the debt due to creditors. Now this is another aspect wherein the creditor is not willing to take up this risk. So for the creditors who are unwilling to wait for the completion of the whole liquidation process for realization of the debt, this new provision enables the creditors to assign or transfer the debt due to them to any other person during the liquidation process. So what it means, like, liquidator also gets the power to whatever is there in the liquidation estate which he forms, and I'm sure you all must be knowing what is a liquidation estate by now. So what he forms after the liquidation order has been passed by NCLT, he can assign these debts to someone else. 30A talks about the financial creditor, like I have a security interest. I am a financial creditor. I am not willing to relinquish my security interest. At the same time, I don't want to wait till the whole liquidation process ends. So for that, this new regulation has come up, 30A. He can also assign this to someone at arm's length basis for the corporate debtor, and both the entities, that's the FC who is assigning and the one who gets the assignment, both would have to go before the liquidator and file this document, so that the liquidator would change the list of creditors which he will file before the honorable adjudicating authority. Next, please. Now, this is actually, this was the talk of town, and this will again become the talk of town, the personal guarantors. So what has happened? While notification dated 15th of November, MCA brought into force some of the provisions of IBC. Now, these sections and all that you can always read up what this is about. This is a part of IBC which gives a right to the financial creditors to go against the personal guarantors of the corporate debtor as well. So, and after this notification of November, lot of applications came to be filed with various adjudicating authorities seeking initiation of insolvency resolution process for the personal guarantors. One of this case was the Lalit Kumar Jain case, and the second one was Anil Ambani's case, which both the cases have been stayed by the Delhi High Court. And then one case was also stayed by the Telangana High Court. And then various high courts started staying everything. And then IBBI filed a petition before Honorable Supreme Court, asking it to be transferred to the Honorable Supreme Court. And today, all the petitions, all the writ petitions are before the Supreme Court. Now, I'll tell you what's the whole issue over here is. What is the contention of all the personal guarantors is, like, CIRP is already ongoing for one entity. You are already asking for the company to be revived. Your claim is already been admitted by the insolvency resolution professional or the RP resolution professional or the liquidator, whomsoever it may be. Wouldn't it just duplicate it? How can a financial creditor get its share from two different proceedings? So that's what I'm saying. One of the major contention is that if insolvency tribunal starts accepting the plea of the banks on personal insolvency, it could lead to initiation of insolvency twice for the same debt. You may be going ahead with the corporate debtor and the personal guarantor separately, distinctively, but at the end of the day, the debt is same. So there is one thing which we need to understand here, and I'm not going more into the legal aspect now because this is sub judice, and we will see the jurisprudence evolving from the Honorable Supreme Court on this. But let us just see from where we have adopted the code, how this has come into picture. So unlike in India and the western part of the world, this is very much prevalent. But over there, what happens is the business owners or the directors, they usually keep the personal properties and the personal belongings and the business belongings as two separate things. Over here in India, what happens, because we are an agrarian economy and we have evolved from there. We are a developing country. So what happens, I'll just give you like a small example. Forget about this whole CIRP thing. Just a business house or a business owner, if he wants to go for a loan, the first thing he will mortgage is his home. This usually mostly does not happen in the western part of the world. And that is why this conflict is coming, because their personal guarantees are being invoked and the personal insolvency is being done. And if you are a guarantor in a capacity as a director of a company, then the whole thing becomes a very painful task for you. So that's one aspect which is not at all a legal aspect. This is more of a practical thing. The legal aspect is still the same, that for the same debt, can you go twice or not? So over here, we are yet to receive an answer from the Supreme Court. But in the case of the corporate guarantee, next please. In the case of the corporate guarantee, in SBI versus Athena Energy Ventures, what has happened, NCLAT clearly stated that simultaneous initiation of CIRP against a principal borrower and its corporate guarantor is permissible. So because these two are entities, we have got clarity from NCLAT, and this is a very recent judgment of NCLAT in the month of November, that yes, you can initiate CIRP for two entities, while one would be a corporate debtor but would be a principal borrower. Another one would also be a corporate debtor because Section 7 would be filed, but it will be in the capacity as a corporate guarantor, and this is very much permissible. Next, please. Yeah, this is a new thing, acknowledgement of debt in balance sheet. There was a hope, then the hope went off, then there's a hope again, then again it went off. When I say hope, from the point of view of the creditors, when I say deadlock, it's from the point of view of the debtors. So what has happened? As we all know, limitation is a burning subject under IBC because various judgments have categorically stated by various forums, be it major of the NCLTs, NCLAT, and the Supreme Court, that the limitation period for the CIRP initiation is 3 years from the date of NPA. Now, one such thing which was brought to the light of the judges at various forums was, can an acknowledgement of debt in the balance sheet be considered an acknowledgement for the purpose of extending the limitation beyond 3 years? Why this was first brought into the picture? Because there are various rules, provisions, and guidelines which requires us or requires the company to file the balance sheets. It will also be supported by an auditor's report, by a director's report. So can that be considered as an acknowledgement of debt, which would revive the limitation time period or the time frame? So in the case of V. Padma Kumar versus Stress Assets Stabilization Fund, NCLAT in the month of March held that the reflection of the debt in the balance sheet could not be considered as an acknowledgement of debt under Section 18 of the Limitation Act, since the filing of balance sheet or annual return is mandatory. Then again, they argued in Vishal Jaiswal versus Arcil matter that this may not be the correct scenario, because as I just rightly said, the balance sheet is supported by various other documents, because right now the concept is not of only the balance sheet, it's the annual report. So it goes with the director's report, the CA's report, the auditor's report. So it was again stated that this has to be referred to the bench one more time. And Honorable NCLAT in the month of December again stated that we are not a constitutional court. And I'll actually would like to read the last two paras because I want you to focus there, because I don't want to comment more, but this is what it is. The 5-member bench judgment rendered in V. Padmakumar's case with a majority of 4:1 was delivered to remove uncertainty arising out of the conflicting verdicts of the benches of co-equal strengths in V Hotels and Messrs. Urgo Capital Limited's case. In view of this factual position, it was inappropriate on the part of the referral bench to doubt the correctness of the 5-member bench judgment, which admittedly has not been appealed against and occupies the field till date. The 5-member bench has taken note of the authoritative pronouncements of Honorable Apex Court relevant to the determinable issue. Therefore, relying upon judgments of various high courts on the subject is of no consequence. This appellate tribunal is not a constitutional court. It is creation of a statute, that is Companies Act 2013. Therefore, this appellate tribunal has to apply the law as embodied in the statutes as laid down by the Honorable Apex Court. This appellate tribunal only interprets and applies the law as it is. So as of now, this is the judgment. So acknowledgement of debt under the balance sheet would not help you to get the limitation. I'll give you one real life problem which most of the financial institutions and the asset reconstruction companies are facing today. No, there are two things, or there are two sides of a coin. First is you cannot initiate a new CIRP for the 1 year period. That is the COVID period. So people are worried. So there's one class of section which are worried about when can they initiate CIRP for the default made in the COVID period. But this is actually a small class. The bigger class is that people who have already enjoyed or initiated the proceedings before various forums, but were not able to or have not initiated CIRP proceedings before NCLT. Now I'll tell you one example. Asset reconstruction company gets a debt from a bank or a financial institution. That would only be done if there was an NPA, right? So if you say that if it's just 3 years after the date of NPA, are we also trying to say that all the ARCs, asset reconstruction companies, would not be in a position to file Section 7? Second point to be considered over here is Limitation Act was for those people who sleep over their rights. Over here, SICA was there. Sikh Industries Companies Act, for which the forums were BIFR and AIFR. Still, debt recovery tribunals are there. Like for an example, I am a bank. I have filed one original application before a bank. It is ongoing. I had hopes that it will culminate into an order someday and it will be in my favor. It was taking time, but I was still patient enough. Meanwhile, what happened? 3 years time period for NPA date went off. So are you trying to say that even if when I was vigilant enough, when I was exercising my right, when I knew my right, and when I was being patient enough with the corporate data, was it necessary for me to file Section 7 within the 3 years time period? So this is yet to be decided by the Honorable Supreme Court. But yes, this acknowledgement of debt in balance sheet has been decided by NCLT, not yet has gone to the Supreme Court, but Supreme Court in other judgments have decided that yes, it has to be 3 years period. So we shall see if jurisprudence would evolve in this prospect or not at a later stage. Next, please. Yeah. So in the Ultratech Nathdwara Cement Limited versus Union of India and others, Rajasthan High Court has categorically stated that the amended Section 31 of the IBC, as per that, central government, state government, or any other local authority to whom a debt in respect of payment of dues arising under any law for the time being in force are owed, have brought under the umbrella of resolution plan approved by AA, which has been binding on such governments and local authorities. So if a plan is there, which has been passed by the Honorable AA, which has come through the route of RP and COC, that becomes binding upon the government entities as well. And this has actually been an amendment in Section 31 and has been clarified by Rajasthan High Court last year in the month of April. Next, please. So the thing is coming from NCLT. Prior to this, there was, I think, NCLT Bombay judgment in metallics forgings case, wherein Mumbai NCLT bench was of an opinion that if a resolution applicant is not willing to go ahead with its plan. We are nowhere, we are no one to force the resolution applicant to go ahead with the plan if his plan with is not willing to do so. But NCLT stated that no, if you have filed a resolution plan, that means that you have you must have had a competition with other resolution applicants. There must have been resolution applicants who must have also filed a resolution plan. The whole period of 180 plus 90 or 330 days have gone through. Your plan was considered at length by the honorable by the committee of creditors in their commercial wisdom. That was checked by the RP, and then it was brought to the notice of the adjudicating authority, and NCLT also has given its sanction or has approved the plan. The whole exercise, time, money has gone through the whole process. Now at this juncture, if the resolution applicant wants to wriggle out of its own commitment or want to withdraw the resolution plan, that should not be allowed. So this is what NCLT stated on 30/9/2020, that we are of the considered opinion that the sanctity of the resolution process has to be maintained, and the resolution applicant whose resolution plan has been approved by the COC cannot be permitted to withdraw its resolution plan. So now this is settled. Next, please. Yeah, so this was a case in the month of February, the JP Infratech case, wherein the preferential transactions were considered in detail. You can just go through it. What are the key ingredients of a transactions to be considered as preferential under section 43. The transfer of the property or the interest of the CD for the benefit of a creditor, surety, or guarantor. Means there has to be a transfer and the benefit should be derived by the creditor, surety, or the guarantor. The transfer is on an account of antecedent financial or operation debt or any other liability. The transfer has the effect of putting such creditor, surety, or guarantor in a beneficial position. And the preference is to be given for a period of 2 years preceding the insolvency date, where the beneficiary is a related party, and 1 year if it's an unrelated party. And the transfer is not an excluded transaction under section 43(3). What are the excluded ones which are in the normal course of the business? So applying a purposive interpretation of section 43 subclause 3, Supreme Court held that the expression corporate debtor or transferee ought to be read as corporate debtor and transferee. It's not or, it has to be read as and. Accordingly, section 43(3)(a) should be read as follows. A preference shall not include the transfer made in the ordinary course of the business or financial affairs of the corporate debtor and transferee. So this ensures the principal focus of the inquiry on the dealings and affairs of the CD is not distracted and remains to its trajectory. Next, please. Yeah, this is a very good case, Maharashtra Seamless Limited versus Padmanabhan Venkatesh, and this was also decided by Honorable Supreme Court, but prior to the COVID lockdown period, but still it's 2020, so I've just included here. Over here, one of the main essence of the IBC, that resolution of the corporate debtor should be given the preference over the liquidation, this was highlighted. So what has happened in this case was the resolution plan which was filed, which was approved by the COC with their own commercial wisdom, the amount or the quantum of that plan was less than the liquidation value. And this was approved by NCLT, and was subsequently challenged before Supreme Court. Supreme Court categorically stated that you are not here to see whether they are giving a better value than the liquidation value. We are supposed to see, is there a revival of the corporate debtor or not? This revival is considered as paramount against the liquidation of the corporate debtor. Next, please. So, and this is a very, very, very recent judgment of Delhi High Court, 26 November 2020. that NCLT has no jurisdiction after the conclusion of CIRP, wherein the Honorable Delhi High Court has stated that once the CIRP is concluded, the resolution professional becomes functus officio. Like earlier I was discussing, right, PUFE application, we talked about liquidation aspect, that financial creditors can sell it off, the liquidator, non-readily realizable asset, can sell it off. Now, what if this PUFE application is filed during the CIRP period, still pending? So over here, Delhi High Court stated that then it cannot continue. If these applications were there, if you see my fourth point, the highlighted portion, thus, if in the opinion of the RP or COC, any transaction is inter alia preferential, then an order in this behalf must be passed by NCLT before the approval of the resolution plan. Because section 23 of IBC, RP manages the operations of the corporate data during the CIRP, and therefore the role of RP commences from the initiation of CIRP and ends at the approval of the resolution plan. Therefore, the RP has no connection with the new management of the corporate data. So now that is upon the new management how they want to do or exhaust their remedy now. And it cannot be an unending process. Yeah, next please. Regulation 2A was inserted in CIRP regulations and was amended on 13th of November. And the new regulation allows the financial creditor to submit the entries in banker's book or the order of the tribunal who has adjudicated upon the non-payment of debt. So over here, I'll just give you a brief background that once you file section 9 or 7, you will have to substantiate yourself with some kind of default, especially with respect to section 7. You will have to file the default with the information utility. Over here, 2A was regulation 2A was inserted, wherein if you get a favorable order from any tribunal or the court of law stating that there is a debt which is due and payable, you can affix that order, which becomes your conclusive evidence or the record of default for the purpose of filing section 7 as per section 7(3) subclause A of IBC. Next please. Regulation 39 with effect from 7/8/2020. This is a very simple regulation that if there are two resolution plans, both of them have to be taken on par by the COC, have to be voted upon on the same time, and the one which gets the more percentage of voting, which obviously has to be more than 66%, should be implemented. Next please. And this was a case wherein Honorable Supreme Court stated that any person can ask for the winding up proceedings which are pending before any high court to be transferred to NCLT. So these are the proceedings we are talking about, which were initiated under the Companies Act. Now they can be transferred to NCLT, and this is the judgment. You people can note it down. Next please. This is also very interesting thing that the operational debt would not take into consideration the leasehold amounts, because it has to be either goods or services, and the leasehold dues would not be considered as an operational debt. So this was actually decided in N. Ravindranath Reddy case, and it was reiterated by Honorable NCLT in the month of November and Promila Taneja, that dues arising from the lease would not fall under the category of operational creditor, and hence you cannot file operational debt, and hence you cannot file section 9 before NCLT for this debts. There are other notable mentions. I'll just go through them very quickly. That if the suspended board of directors wants to raise any objections for any material irregularity in the CIRP, they have to do it before the COC, before the plan is approved. And after the plan is approved, it has to be taken before the NCLT. And one case was also there with respect to Rule 11, because Rule 11 talks about the inherent powers of the Honorable NCLT. And it was decided by NCLT that this does not give us the power to correct or to do the review. It is only for the correction of the mistake, not for the review. Next, please. And now let's move on to the last part of our webinar, or the last part of the PPT. What's the road ahead and what are the anticipated changes? So one of them is, and the foremost one is the Prepack Insolvency. And so there are a few things which you can just read upon. I'll just brush it through. What's the functioning? So Prepack is a restructuring plan which is agreed to by the debtor and his creditor prior to insolvency filing, and then sanctioned by the court. So over here, what would happen? The creditors and the corporate debtor would sit privately, decide. A plan is filed by either by the debtor or by some external entity. Once everything is finalized, then they can go to NCLT for the approval. Now, what's the advantage? Advantage over here is it's fast. It's actually cost effective. Also, the business is not disrupted, because over here what will happen, the corporate debtor would be under control till the time the plan has been approved by NCLT. In CIRP, what happens that NCLT would appoint IRP and subsequently RP, who will be having the control of the whole process. But in this, the debtor would be in the hands of the erstwhile management only. But what are the disadvantages of this? Like, because it's not publicly open that this entity is going for the insolvency, we may not get more bidders for that. We may not get more resolution applicants for that. Also, the issue of transparency would also come into the picture, that there is less transparency because everything is happening privately. Next, please. So what are the key recommendations of the subcommittee? So the subcommittee does not recommend any specific provisions or removal or replacement of RP except in the case of death. So there has to be one RP who would run the whole process, because he would be more of a facilitator rather than the person who will be taking the decisions, because the decisions would be taken jointly by the debtor and the COC. And conclusion of this whole thing is that Prepack scheme is not a substitute to the existing framework, because what they are planning as of now, because still in the planning stage, what they are planning is, first it has to be for the entities whose defaults are COVID defaults. When I say COVID defaults, is 1 lakh to 1 crore. And then they will see what are the pros and cons and how to manage it. Because obviously the IBC had teething problems. This may also have some teething problems. And then they may also include below 1 lakh, that is from 1 rupee to 1 lakh, and from 1 crore to n number of amount. So what they are planning to do is, if they can reduce the burden of NCLTs by giving giving the opportunity to the corporate debtor and the creditor to restructure the whole company before even going before NCLT, so tribunals would be less burdened. It is going to be cost effective because the company is ongoing. There is a less chance of the jobs being snatched away, because the corporate debtor would still be an ongoing entity. And also you consider one very important aspect, that right now it is actually prudent for the person who was handling the whole company to take care of the affairs on a continuous basis rather than a new person stepping in, because this is not the time people are ready to invest as well. This is not the time when people are willing to go beyond and want to take a risk. So this is the time where revival is more important, resolution is more important, and this Prepack can actually help in that. Next. I think I'm done, and if any questions are there, they're all welcome. Ria, you may stop the PPT. And one more thing I'll just like to add before we take up the questions. There's one more thing in the road ahead path, is the concept of a good bad bank. And you must have heard about it, that just like the way ARCs are there, we are also contemplating, in the sense the government and the Ministry of Corporate Affairs and everyone, the Finance Ministry, they are contemplating to have a bad bank, which should be a good bad bank. So a bad bank is a bank which would take up the assets, the stress assets or the toxic assets from the bank. And the whole purpose or the objective of that bad bank would be to make them profitable, and so that what happens, the banks which are the commercial banks would continue with their own banking system. They'll focus on the banking and ensuring the economy is going good. Their balance sheets are tidied up, or they are made good. All the toxic goes out, and the bad bank would only cater to those accounts which are NP and toxic, and try and revive them and make them into a profitable entity, or at least the entity wherein the maximization of value of all the creditors is there. Thank you so much, guys. I hope you enjoyed the PPT. I know I went a bit quick because I wanted to cover a lot, and I may take your questions now. Thank you so much.
As sir said, the forum is open for questions. So, okay. So there's a question from Aditya Sharma. The question is, could you throw some light as to what is the order of preference given to creditors during insolvency proceeding? Is there any disadvantage to creditors who is incorporated outside the jurisdiction of India? For example, any foreign company having a stake here?
No. So it does not matter if the creditor is an Indian entity or an international entity. There is no bifurcation. So I've answered the second question, that there is no separate treatment for the entities who are the creditors. To answer the first question is section 53, the waterfall mechanism. It states how and who will be paid first and who will be paid last, as per the resolution plan, as well as when the company goes into the liquidation. So first are the CIRP cost, the cost of the RP, and the labor dues, and the financial creditors, and the last would be the equity and the preferential stakeholders. Above that would be the government entities, because the government entities are also considered as operational creditors here. So section 53, if you can just go through it, that will give you the whole waterfall mechanism, how it will be distributed.
Okay, so there's another question from Ritik. The Supreme Court in Babulal Virji Gurjar has held that Section 18 of Limitation Act will not be applicable for the purpose of CIRP process, which on the very outset excludes the whole enigma of balance sheet entries. What are your thoughts on that?
Yeah, so see, balance sheet entries is I am still in between, because if you think from the point of view of the creditor, there is an acknowledgement, right? You are stating in your balance sheet that I'm due something. But if you see from the point of view of the debtor, he always has to take a shelter on all these technical aspects if he's unable to pay the debts. So as I said, that the whole limitation thing is only stands in between, because it is from which point of view think. No, because the limitation, the purpose of limitation was that the person who's sleeping over the rights should be thrown out. But what if someone was very much vigilant? So what if you had a case which was under SICA? What if you had an OA filed before DRT, and there is an acknowledgement in the balance sheet? Are we still trying to say that he cannot file a Section 7 because he was not sleeping over the rights, right? So as it's still yet to be the jurisprudence in this whole aspect is yet to be evolved, and I still feel the Supreme Court would someday still reconsider its own judgment, and we shall still see something happening in this limitation thing, because I'm still hopeful that there has to be a representation from both the sides equally, and let us leave it to the Supreme Court and its wisdom to come up with that.
So the next question is from Komal. She wants that you briefly explain the concept of good and bad bank again.
Yeah, so it's more like an ARC, asset reconstruction company. So so the good bad bank is, I'm just saying, what is a bad bank? So what is a bad bank? A bank which takes the bad debts of a bank, a commercial bank, and makes it into its pool and try to see if there can be a recovery, can there be a revival, can there be a maximization of assets. A good bad bank is the one which has been formulated nicely by any government and been backed by the government for its purpose, and it's for running that bank separately, would not take care of other commercial activities of a bank, would only concentrate on reviving those assets and taking the maximum out of those bad debts, would be a bad bank. A good bad bank would be a bank which has got a good backing from the government for running a bad bank. I know it's more like a tongue twister, and I only twisted it twice, so that's how it is.
Okay, so the next question is from Sneha. She wants to know what is the role of IBC in the development of credit market in India, especially in 2020. Given the fact, I think 2020 half year was already in lockdown. I'm not sure.
No. Can you just repeat the question? What was the role of IBC in
development of credit market in India, especially in 2020?
I don't think there was any role, because still the suspension is ongoing. The role of IBC would be seen at a longer run. See, as a legislation, it has always been a fruitful legislation. All the predecessors, for an example, this is a time-bound mechanism. The moratorium is there. Unlike SICA, we have got a time frame, and everything is happening with the consultations of the COC. So it's more of a creditor-driven regime. So IBC has always been a beneficial legislation. And to be honest, I still feel that we, for first 4 to 5 years, had teething problems with IBC. And this is the time the IBC would be picking up. Let this suspension go away. Let there be a bad bank there, and let there be prepacked insolvency. Then it will be after 10 years or so, we'll be able to see how it has impacted the credit of the credit of our economy as a whole, rather than seeing 2020. No, forget about IBC. The credit of economy was hit hard. Any economy was hit hard due to COVID.
Thank you. So the next question is from Aditya. He wants to know, how does the provision of automatic early termination in certain financial agreements governed by English or New York law such as ISDA interact with the Indian law?
So for that, we are to see the interplay between the cross-border insolvencies. See, if you are trying to say that those insolvencies which are filed in the foreign jurisdiction, there we are yet to see the involvement of the cross-border insolvencies. If you're trying to ask what about the entities which are foreign entities but are the creditors to the corporate debtor who are Indian, they are treated on par. They are treated on par. There is no difference. So if you want to see the interplay of those jurisdictions and ours, then you still need to wait for the cross-border insolvency to be kicked in.
So the next question is from Sakshi. She wants to know, what are your views on the personal guarantee of Anil Ambani's case?
It's not just one Anil Ambani's case. It's there are, if I'm not wrong, more than 15 to 20 cases are there in the whole batch, and even my cases are there. So those all cases are still there. Supreme Court is yet to see how it goes. Jurisprudence is yet to be evolved. We are not here to make comments on how the process goes on. But yes, what I can say is there was an enactment. There is an enactment which was invoked because of the notification that has been stayed by various high courts. IBBI wants to justify it. There are various advocates who are appearing on behalf of the personal guarantors who have serious concerns about the same debt being challenged or being asked to be tried at various forums again and again. So it's just, let's wait and watch. And I think that this matter is already ongoing. In a couple of months, we'll get the outcome, and let's hope for the best, because we bow down to whatever Supreme Court states.
Okay, so there's a follow-up question on the balance sheet and limitation from the same person. He wants to know that if the balance sheet entry is taken as acknowledgement, then there will be no case when it would become time barred, as the company is mandated by Section 92 of the Companies Act to file for balance sheet every year. Also, with respect to Supreme Padma Kumar was formed to clear the same conflicting issue, and the 5-judge bench rebuked the referral bench for raising the same issue again, the relevant para which he said you should have quoted in your slide or quoted in your slide. So what are your views on that?
But still, see, I just quoted the end result. What was that? That it may not be considered. Now, what they have considered is, according to him, it must be just one relevant para. According to you, it can be two. So, and if I missed out on some para, I'm sorry, brother or sister. I'll take care and I'll note that down.
The next question is, IBC has successfully more of a revivals or dissolution of companies. Which side IBC has played more?
It's more of a revival. For sure, it's more of a revival.
Okay, so there was this question from a few people that whether you'll be able to share the slide that through which you run everybody through with them or everybody who joined in webinar today.
I don't think I'll have a problem, but because it's a firm slide, I'll just go back to my firm. But nonetheless, I mean, I think this is being recorded and this will be on the YouTube platform. So whomsoever wants to go, I mean,
so anybody wants to have access to the PPT can see the recorded sessions later on YouTube.
You can see the YouTube, and you can also skip through that as well.
Yeah. So this is just a appreciation post from Aditya. He's an ISD lawyer, and he says the presentation was very helpful, and thank you, sir. So thank you, sir, for joining in. It was a wonderful session. You run us through very crucial points that generally people have to research through in depth. We are very glad to have you today here. And I think everybody who joined in session could have some takeaways from your session. Thank you so much. Thank you so much to your fellow associates and junior associates who joined in and helped you throughout for the presentation. Thank you so much, sir, for joining in.
Thank you. I'd like to thank the lovely participants, because from their questions, I could gather that, they were spot on and I did not make them sleep by any means. And yes, thanks to both the associates, again, Ria and Rishika, for this lovely presentation. Thank you, the whole Law Seco team, and have a good weekend ahead. I mean, it's almost over, but have a good night's sleep, and keep revolving, keep enriching each other. Law Seco is a good platform. Even I attend their webinars. If I don't attend, I'll also go through their YouTube channel. So it's a good platform. You people are doing very good. So give my appreciations to Ramanujan and everyone. And thanks for having me.
Thank you, sir. Thank you so much. Everybody have a good day. Same to you, sir. We'll be ending the session.